This video is called Asset Protection Trusts Compared, U.S. States versus Cook Islands, Belize, and Nevis, and what actually works. And that's exactly what we're diving into today. And in the next 60 seconds, you're going to see why one side quietly loses in court far more often than most people realize. And I'll give you the payoff early. Domestic trusts sound strong on paper, but offshore trusts are strong in real courtrooms. Most people don't understand the difference until it's too late. So I'll prove it to you with real examples, simple explanations, and a side-by-side comparison of Nevada, South Dakota, Delaware, to Cook Islands, Belize, and Nevis. And very quick credibility so you know who's guiding you. I'm Kevin, the business guy, the CEO of the Lawyers Limited Law Firm and Asset Protection Planners, which is our sub-brand that specializes in asset protection. I've been in asset protection for 34 years, and for 30 years, I've been setting up Cook Islands trusts. In fact, my team and I have set up more Cook Islands trusts than any firm in the world. So if you like deep dive content, go ahead and subscribe. I recommend that you follow somebody who helps you make money. And what's the point in making it if you'll lose it all in a lawsuit? Subscribe to my channel and I'll help you keep your money. And hit the notification bell so you get the next one automatically. And if any point you think this applies to me, you can visit assetprotectionplanners.com anytime for a strategy call. But for now, let's get right into it fast. Okay, domestic versus offshore, two completely different universes. And there are only two universes in this asset protection trust world. Universe one, domestic trusts. Nevada, South Dakota, Delaware. These are U.S.-based trusts under U.S. law, under U.S. judges, under the U.S. Constitution, rules like full faith and credit. What that means is a judgment in one state can be enforced in another state. They feel familiar, they sound safe, your CPA nods when you mention them. And then there's universe two, offshore trusts, Cook Islands, Belize, Nevis. These live outside of the U.S. jurisdiction. U.S. judges do not control them. Foreign courts do not honor U.S. judgments. Now, if you live outside the U.S., Canada, Australia, UK, for example, we still have clients in those jurisdictions as well, and similar rules apply. So creditors must start their lawsuits over again in the offshore country. So this is the single biggest difference in all of asset protection. A domestic trust is like putting a safe in your living room. An offshore trust is like putting that safe in a different country behind armed guards who ignore U.S. court orders trying to take your money away. Now, before we talk about statutes and features, I want to give you some instant value. Immediate takeaway. Domestic trusts rely on cooperation from U.S. judges. Offshore trusts eliminate that requirement entirely. So that's why high net worth people gravitate offshore once they understand the landscape. Okay, the domestic trusts, Nevada, South Dakota, and Delaware. These are three of my favorite jurisdictions. So Wyoming as well. So let's go ahead and break down the three major U.S. asset protection trust states. Nevada, the pros, allows self-settled spendthrift trusts, and you can be the beneficiary. Short statute of limitations for challenges. You can publish in the newspaper the assets that you're putting into the trust, and then you can shorten it down to a 6-month statute of limitations on fraudulent conveyance. No income tax in the state. You still have to pay your federal tax and the state tax where you live. Strong marketing presence. Now, here are the cons, the bad things. Still under U.S. judges. Full faith and credit still applies. Public policy overrides apply. Nevada is like the kid at school with the nicest sneakers. I mean, they look good until you see him run. He can't run very fast. A judgment in California, we have seen over and over again, can penetrate a Nevada trust every time. Okay, next, South Dakota. And this is my personal favorite for domestic trusts. Pros, extremely strong privacy laws, greater for dynasty trusts, which where you pass wealth to different generations, and estate planning. Some creditor protections similar to Nevada, highly sophisticated trust industry, excellent administrative environment. Now the cons is still under, as we said, U.S. judges and full faith policy rules. We rarely rely on it for pure asset protection alone. Now, South Dakota is phenomenal for wealth planning and long-term structures. For asset protection from lawsuits, still limited. Okay, next, Delaware. The pros. It's old, established trust industry, corporate-friendly environment, allows domestic asset protection trust. Now the cons, bad things. Longer statute of limitations on fraudulent conveyance. In other words, your creditor has a longer time to challenge the transfer of assets into the trust after you've established and funded it. Less favorable for certain types of creditor claims. Still under the U.S. jurisdiction. So Delaware is like the old classy school bank, great reputation, but not the strongest vault. Okay, now here's the fatal flaw of domestic trust. And here's where U.S. trusts run into unavoidable problems. Number one, full faith and credit clause. Again, U.S. states are required to honor each other's judgment. So in California, the judge says you owe money. Nevada doesn't get to say no thanks. Number two, public policy override. A judge can ignore another state's trust protections if they violate that state's sense of fairness. In plain English, if the judge thinks that you moved assets to dodge a creditor, they can order you to pay anyway. I mean, think about it. Do you think they're going to, do you think that trustee in Nevada is going to give up his own money or yours since the judge has jurisdiction over him? Do you think he's going to go to jail for contempt or give up your money? They don't have that fear when it's an offshore trust. So that's the huge difference. Number three, contempt of court. And this is the nuclear option. And we're just talking about that. The judge can say, turn over the assets or go to jail. And this happens even if your trust is in another state. And they say that to the trustee, by the way, not you. Domestic trusts do not protect you from your judge. And now, micro cliffhanger payoff, we're going to look at a real world example. And here's a case study for you. The Nevada trust that failed. John, here's a kind of a composite of real clients we've seen over 3 decades, lives in California, owns rentals worth $4.5 million. He has a business. He sets up a Nevada asset protection trust, leaves assets in the U.S., fills bulletproof. And then a tenant suffers a major injury. Lawsuit hits. California judge sees the transfer and the Nevada trust. The judge says, Mr. John, instruct your trustee to return the assets. So John tries to explain Nevada's protections, but the judge doesn't blink. So do it or I'll hold you in contempt. Nevada law does not help him because Nevada law does not control California judges. So domestic trusts work until they don't. That's the thing. These promoters will, talk about how great they are. And yet when you actually look at the case law of domestic trust and we look at the case law of offshore trust, it's a totally different situation. And when the domestic trusts don't work, they really don't. Okay, now let's look at the offshore side. Okay, now offshore trust, Cook Islands, Belize, and Nevis. This is where everything changes. Now these countries wrote their laws specifically to protect assets from foreign judgments. Cook Islands Trust, we've set up more of Cook Islands Trust than anybody in the world. This is the gold standard. And this is really the original, the most heavily tested. Key points. U.S. judgments are not recognized. And if you live in Australia or Canada or UK, well, we set up trusts for people in those jurisdictions as well. So your judgments aren't recognized. Creditors must sue in the Cook Islands. Burden of proof is extremely high. The statute of limitations is short. That means once you set it up and fund it, your creditor can't challenge it. It's protected right away. They have a short window to challenge, but we've never seen anybody win that challenge ever. Contingency lawyers really hate these cases. Our law firm, like I said, has set up more Cook Islands trusts than anyone in the entire world, and they've proven themselves again and again across nearly 30 years. Okay, next, Belize Trust. We set up many in Belize. That's Cook Islands being in south of Hawaii in the Pacific. And Belize is in Central America. It's an English-speaking country in Central America. Belize takes an even harder stance. Foreign judgments explicitly are not recognized. Strong fraudulent transfer protections. Excellent choice for clients with lawsuits already filed. They can act as a firewall jurisdiction. The nice thing about Belize, once you put your assets in there, they cut off the ability to challenge that transfer, and your assets are protected immediately without even an option of filing a fraudulent transfer action in Belize. So it protects assets immediately. And the reason why we choose Belize is if you're already in litigation, because they're less, where Cook Islands is not too fond of taking people already in litigation. They will, but a lot more scrutiny, where Belize is more open to that. Nevis Trust. Nevis is in the Caribbean. It's the southeast of Florida. I've been there many times. I have the cell phone number of the premier of Nevis. It's the head politician in the jurisdiction. We text each other, talk to each other on Facebook. And like I said, I've been there several times. Beautiful Four Seasons hotel there. Creditors must post a cash bond, often $100,000 plus just to start. Very strict rules for suing suing a trust there. Pairs beautifully with the Nevis LLC inside the trust. The Nevis LLC holds the bank account, allows you to be manager of that LLC while waters are calm, and your trustee company steps in when things get rough. So very creditor unfriendly territory. So somebody trying to sue you, they're not going to be too happy there. So the common thread of these three jurisdictions are no U.S. judge can force a foreign trustee to obey, period. And that brings us to the structure, the engine behind everything offshore. The Cook Island structure, trust plus LLC plus what we call the storm switch. So what do we mean by that? Here's the exact structure that we use for high net worth clients. We set up an offshore trust, Cook Islands in most cases. This is the purple rectangle here. Represents the offshore trust, Cook Islands Trust most often. And so that's the vault. Now, inside the fortress, we put an offshore LLC, typically a Cook Islands LLC. It goes inside of your Cook Islands Trust. And this is owned by the trust. And again, that's the vault inside the fortress. Next, the client. You are initially the manager of that LLC during calm times, meaning you have full day-to-day control. And when a major lawsuit hits, the offshore trustee company can step in as LLC manager here, okay? So the trustee company becomes the manager. They're licensed, bonded, very, very heavily regulated. So this is the storm switch that I promised. So it works like this. Calm seas, you run everything. Legal hurricane, professional offshore trustee company steps in to protect you. So when a U.S. judge orders you to turn over your assets, you can't because you're no longer the manager. Now, you can get the money anytime you want to, but your enemy at law cannot. And the foreign trustee is not subject to U.S. court orders. So that is how real protection happens. Now, let's compare John's story again, this time with the offshore trust. Remember, John lost his money because the California judge didn't respect the Nevada trust law. Let's look at John again. Same real estate, same business, same lawsuit, but this time he set up a Cook Islands trust like illustrated here. The assets are held in the Cook Islands LLC. We put each piece of real estate into a separate land trust. We make LLCs. The beneficiaries of the land trust that hold rental properties, and then we record liens against each property here and to suck out the equity. And if needed, we get a third-party lender. So the proceeds from these liens go into your offshore Cook Islands Trust. So there's really nothing in the U.S. to take or in your country, wherever you live. So he's the manager of the LLC inside the trust when things are calm. So, and then when things get stormy, the trustee company, law firm, can step in to protect you. So here's what happens. California judge says, Mr. John, bring the assets back. John says, Your Honor, I legally cannot. I'm no longer the manager. So what happens next? The judge can't hold him in contempt, but contempt only works if compliance is possible. John cannot comply. So the Cook Islands trust law protects him, and the creditor must sue in the Cook Islands. So most contingency fee lawyers do not even take the fight. So the case settles for pennies or collapses entirely. So that's the difference between paper protection, where these promoters in Nevada, get all excited about it, and real protection, where firms like us have studied the law and the case law and seen what actually works, and we guide our clients in that direction, in what actually works in real life courtrooms, because that's what really matters, right? Okay, now let's talk about Belize and Nevis and where they fit in. Each offshore jurisdiction has a specialty. Belize, best for people with lawsuits already in motion, very aggressive creditor environments, hardline fraudulent transfer defenses. So Belize is a don't even try it jurisdiction. Next, Nevis. Nevis is best for LLC protection plus trust protection, situations where we want bond requirements for creditors, additional roadblocks. Nevis basically says, you want to sue? Bring cash. They have to, post, for example, a $100,000 bond in Nevis even to bring a suit. Cook Islands. best for high threat levels, most lawsuits, largest net worth cases, most court-tested history. And that's why we use Cook Islands as the main trust 90% of the time. Belize and Nevis are excellent add-ons or alternatives when the fact patterns call for it. Now here's what to use based on risk and net worth. Let's say under $1 million. Well, have insurance. You can have domestic LLCs, possibly a South Dakota trust, Cook Islands Trust plus Cook Islands LLC if the assets are above $500,000. And an offshore trust becomes ideal once the risk grows. $1 to $3 million net worth. Cook Islands Trust plus Cook Islands LLC, domestic LLCs, possibly a South Dakota trust. We do equity stripping of real estate. Offshore trust becomes ideal once the risk grows. $3 to $10 million net worth. Cook Islands Trust plus Cook Islands LLC. Domestic entities hold real estate. Layered liens, equity stripping for properties. Asset protection becomes more serious here. $10 to $20 million plus net worth. Cook Islands Trust as the main structure. Offshore LLCs for holding accounts and liens. Domestic LLCs and land trust for real estate. Optional South Dakota trust for estate planning, passing wealth on to your heirs. Now, the offshore trust also has estate planning built in as well. Nevis and Belize as additional layers when appropriate. Now, here's a simple summary. Domestic is useful but limited. Offshore is the strongest, most proven protection. Okay, now let's go ahead and land this plane. Here's some final takeaways and what actually works. So let's simplify the whole video. Number one, domestic trust, Nevada, South Dakota, Delaware, Wyoming as well, pros. Good estate planning, some creditor protection, familiar and easy, and they can work well if you actually live in one of these states. Most states don't have domestic asset protection trust laws, but if you live in that state, it's better than if you live outside the state. If you live outside the state, forget it. It's not even a good option, because judges can override them with the full faith and credit laws. Contempt power exists. No separation from U.S. jurisdiction, and they're not lawsuit proof. Number two, offshore trust, Cook Islands, Belize, and Nevis. Pros, foreign jurisdiction, foreign judges. U.S. judgments are not recognized. Creditors must start over offshore. It's extremely expensive and difficult for your creditor to attack. Proven in real litigation. Here's some cons. Might be thought of as more complex. Easy for us. It's something we do every day of the week, and we do it for people all over the country, all over the world. Requires expert setup. So that's where we come in. And these are the strongest asset protection structures on earth, period. Okay, here's the winning structure, the Cook Islands Trust with the Cook Islands LLC inside of it. You as the manager in calm times. Offshore trustee as the manager when storms hit. So layers of domestic LLCs and lien strategies underneath. So this is the structure, like the illustration that we showed. You're the LLC manager. The bank accounts sit in your offshore trust, and you're the manager of that LLC. When things are calm, your trustee company, law firm, becomes the manager when things get stormy, and a judge could order you to bring money back. We want to put you in a position of impossibility to do that. And we talked about your real estate. Land trusts hold the title to each property. LLCs are the beneficiaries of those land trusts, and a land trust is the beneficiary, and a land trust holds the title to your personal residence. So this is the structure that has protected our clients for nearly 3 decades, and the reason our firm has set up more Cook Islands Trust than anybody in the world. So if you're watching this and thinking, I've worked too hard to be this vulnerable, feel free to go to assetprotectionplanners.com. You get a whole lot of free information. Just get the free information. You don't even have to call us. But if you want to, if you're serious and not curious and you have over $500,000 to protect, request a strategy call. You can do that online. So we'll walk you through exactly what fits your particular situation and risk levels. And also make sure to subscribe so you don't miss the next deep dive. See you next time.